structure of Islam was actually established, and this verse was actually brought into implementation. Then, who is going to be the first successor? That is the very another significant thing. So it was none other than Ali ibn Abi Talib alayhi salam. So when the Prophet Muhammad in 10 al-Hijri was returned. That is the very another significant thing. But in 10 al-Hijri was returned.
So good afternoon everyone. I hope everyone is doing fine and you all have enjoyed your weekends. Good afternoon Anaka and everyone, good afternoon. So I hope my audio and video both are clear to you and you can easily read the PDF. Let me zoom it a bit more so that you can read it easily. So this week we are going to take up some important judgment summaries, and these are the important judgment summaries from 2021. These are the important case laws from 2020 and 2021. So, we have come up with important things. Okay. Please tell me if my audio and visuals are clear to you and you can read the PDF document easily. Please tell me. Good afternoon, everyone. Everyone, good afternoon. Okay, so let us begin. Okay, thank you. So today's case is Laxmibai Chandaragi versus the state of Karnataka. You must be remembering that in the last week we discussed certain important issues, and the preceding week of the last week we discussed certain important judgment summaries. One of them was the Shafeen Jahan versus Ashokan KM. So Shafeen Jahan versus Ashokan KM was one of the landmark judgments from 2017, in which is popularly known as the Hadias case, in which the Supreme Court categorically recognized and constructively brought right to marry a person of your own choice as one of the fundamental rights within the ambit of Article 21 of the Constitution of India, which contains right to life and personal liberty. So that is one important aspect. The cases relating to matrimonies and marriage, they are in abundance in Indian judiciary. Today we have a lot of matrimonial disputes. The Family Courts Act of 1984 has also established a special family court, which shall be presided by a family judge, who is going to be of the rank of ADJ. So it has been established in almost every district of subordinate courts, the Family Courts Act. So all the matrimonial disputes and all the matrimonial issues are tabled and decided by the family court. Okay. So the issues relating to matrimony or the issues relating to marriages have fall completely under a separate category. This is yet another specialization in the field of law, and many lawyers, they specialize themselves in matrimonial issues. So this matrimonial issue is like before the Supreme Court. When it reaches the Supreme Court, comes out with a ruling. And the judgment of the Supreme Court is like that of a law which is binding on all courts across India, including all high courts. So whatever the Supreme Court says or rules becomes the law. Okay, because the interpretation of the Supreme Court, the interpretation of any law by the Supreme Court is full and final. It has to be taken and it has to be bought, whether one likes it or dislikes it. Okay. The case of Laxmibai Chandaragi versus the state of Karnataka is in close resemblance with the case of Shafeen Jahan versus Ashokan K, in which the Supreme Court recognized right to life and personal liberty, right to marry a person of your own choice as part of right to life and personal liberty. Hadiya was earlier a Hindu girl and who fell in love with a Muslim man, and they both married. They both, married, and this girl Hadiya embraced Islam, and she started doing hijab and all that, and she embraced Islam and converted to Muslim. So this became a national issue. The parents of Hadiya took this issue to the Supreme Court, and the Supreme Court finally decided that right to marry a person of your own choice is the right of every adult person, whether male or female, and it's an important ingredient of right to life and personal liberty under Article 21 of the Constitution of India. So the case of Laxmibai Chandaragi hails from the year 2021. You can see some of the important details are written here: the name of the case, the court, the citation, the bench, the date of judgment also. So some of the people in Rostrum Legal are working brilliantly. I must appreciate them. So Laxmibai Chandaragi versus the state of Karnataka is one of the topics that discusses one of the cases that discusses the topic of intermarriage and the ability to choose one's spouse once again. This judgment addresses the topic of intermarriage and the ability to choose one's spouse. But what distinguishes this case, every case has its own face. We cannot say that the one case is exactly like that of another, even though there may be some similar issues in the two cases, but the two cases might be having two different circumstances where the events would have unfolded in different circumstances altogether. So the issues might be similar, and some of the issues might be similar, but we cannot say that the two cases, you should know this rule, that the two cases can never be congruent. Can never be congruent. They may be similar, they may have similar facts, they may have similar issues, but every case is different and every case comes with its own face. So Laxmibai Chandaragi versus the state of Karnataka bears some resemblance with Shafeen Jahan versus Ashokan KM case or the Hadiya's case, but it is not exactly like that of, it's not exactly like that. It has certain other issues also. Okay, so this judgment addresses the topic of intermarriage and the ability to choose one's spouse. In addition, the decision considers whether or not the consent of family and community is required for marriage. What happened in the Shafeen Jahan case or in the Hadiya's case? That the consent of the family and the consent of the parents was given primacy over the choice of one's choice to marry a person. Okay, so this was given by the Kerala High Court, which was later overruled by the Supreme Court. Okay, it says that we have certain virtues in our society, like respecting the opinion of the parents and obeying them. But these virtues, these customs, these traditional setups cannot override your fundamental rights. Whenever any custom, tradition, or sanskar, they come in conflict with your rights, the rights shall have the primacy over these kinds of things. So the Kerala High Court wrongly gave primacy to the opinion of the parents because of our societal setup. And this has to be like this, that the fundamental right of Hadiya has to have primacy over the choice of the parents. So exactly that's what again this case discusses, Laxmibai Chandaragi versus the state of Karnataka. This judgment addresses the topic of intermarriage and the ability to choose one's spouse. In addition, the decision considers whether or not the consent of family and community is required for marriage. It investigates Article 21 of the Indian Constitution, which establishes the right to life. Okay, facts of the case. Now let us read the facts of the case. I hope I have not initiated any discussion which might sound confusing to you. If you have any confusion or ambiguity, please take the liberty to ask me anything right now. Before we start reading the facts of the case, let us now understand that if you are not well aware with any of the things, whatever I have said, so kindly tell me. Are you all right up till here? Any question, any query? Okay. Now let us start reading the facts of the case. Miss Laxmibai Chandaragi went missing on October 14, 2020. Okay. See, read the facts of the case very carefully, because in every criminal case, facts are very important. The issues are framed accordingly. If you want to become a criminal lawyer, you have to have you have to be very good and very witty while reading the facts of the case and bring out the new and different nuances out of it, because 90% of in every criminal case dwells upon the facts. Okay. And this is a kind of thing like which is very commonly which is very common. As a lawyer, I must tell you that I have also confronted cases like this, because where a Muslim boy fell in love with a Christian girl from South India, and she wanted to come back. She absconded from home. Then she was apprehended by the police on the next station because she was trying to come down to New Delhi. So these kinds of things have happened. Okay, and these are very common. As a lawyer, you would be confronting with these kinds of cases every now and then. So please be very careful and be very witty while reading the facts of the case. Miss Laxmibai Chandaragi went missing on October 14, 2020. Associate degree FIR was filed on behalf of her parent, Mr. Basappa Chandaragi. The statements of parents and relatives were recorded by the investigation officer. When the decision records of the woman's phone were retrieved, it was discovered that she was in frequent contact with a man named Mr. Santosh Singh Yadav. Without alerting her parents, the lady took a trip from Hubli to Delhi and married the man. On the future date of 15th October 2020, she emailed her wedding certificate to her parents via WhatsApp and informed them of the factum of a marriage to the man. So what happened? There was a girl, Miss Laxmibai Chandaragi. She went missing on October 14, 2020, and actually she absconded from her place. And later, when her whereabouts were not known for a very long time, for so many hours, then her parents filed an FIR, and the investigation officer recorded the statements of the parents and the relatives. And when some investigation was done by the investigation officer, it was discovered that she was in frequent contact with a man named Mr. Santosh Singh Yadav. So actually what had happened, that without informing and alerting her parents, the lady took a trip from Hubli to Delhi and married the man. On the future date of 15th October 2020, she emailed her wedding certificate to her parents via WhatsApp and informed them of the factum of her marriage to the man. So suddenly the parents came to know about that the girl had already absconded from Hubli and she has reached Delhi, and she has already married this man, the man she was in frequent contact with for so long. So she then emailed her wedding certificates to her parents via WhatsApp to inform them about the fact of her marriage with the man. So the investigation officer traveled from Karnataka to Ghaziabad and visit to the man's house. Okay, so investigation officer traveled from Karnataka to Ghaziabad and he visited man's place. The IO was informed by the man's parents that they were ignorant of the couple's whereabouts. When the investigating officer made contact with the lady, she informed him that she had married the person and was now living with him. So when the investigating officer visited the man's place, so he came across that man's, like Santosh Singh Yadav's parents, and the parents contended that they were ignorant of the couple's whereabouts. They don't know anything about where this couple is putting up. So when the investigating officer made contact with the lady, she informed him that she had married the person and was now living with him. Rather than recording her statement, the investigating officer insisted that she return to her hometown in Karnataka and appear at the Murgaon police headquarters to record her statements in order for the matter to be completed. Now this is a legal procedure and legal formalities to be completed. The investigating officer asked her to come back to her hometown in Karnataka and get this statement recorded that whatever she did was out of his own will, and she absconded because she had all this liberty and freedom to do that being an adult. And she in order to close the case, you have to come down to Karnataka, to your hometown in Karnataka, and get your statement recorded so that we can close this file. Okay, so the investigating officer insisted that she return to her hometown in Karnataka and appear at the Murgaon police headquarters to record her statements in order for the matter to be completed. Like the police or the IO, the investigating officer wanted to close the file, because now this is not a crime. If she is an adult and she has absconded out of her own free will to marry a person of her own choice, then that's the law. Okay, nobody can stop her. So in the letter written to the IO, the lady refused to follow, alleging a danger to her life from her parents if she returned. In the letter written to the IO, the lady refused to follow, alleging a danger to her life from her parents if she returned. Now this lady, like what's her name? Chandaragi, Laxmibai Chandaragi. So Laxmibai Chandaragi wrote a letter back to the investigating officer, and she refused to follow the instructions of the IO because she was apprehending some danger to her life from her parents if she returned. Like she was apprehending her honor killing. The IO, however, ignored her statement and her concerns about a threat to her life and refused to close the case. The IO said that I am not going to close the case. This will keep on being investigated again and again, and you will be disturbed and perturbed by the different investigating officers time and again. So it's better that you come down to this place, get your statement recorded, and go back. That's it. That's all you have to do. But she refused that I am not going to come back to that place because I fear danger to my life, because my parents might kill me. So I am not going to come to that place. So in the letter written to the IO, the lady refused to follow, alleging a danger to her life from her parents if she returned. The IO, however, ignored her statement and her concerns about a threat to her life and refused to close the case. The IO said, I am not going to close the case because that's a legal procedure and that's a legal mandate that you have to follow. That if you want this case to be closed, you have to come down to this place and get your statement recorded, because that's the law. I cannot close the case merely on your phone call and merely on a letter written by you. You have to come here, be there physically present in the police station and get your statement recorded. That's the legal procedure and that must be followed at any cost. So the IO, however, ignored her statement and her concerns about a threat to her life and refused to close the case. The written transcript of the spoken wording between the lady and also the IO that was submitted to the court revealed unequivocally that the IO threatened the lady and also the man with registering a false case against the person for seizure and also the girl for larceny in her house in order to compel her return to her hometown. Okay, so the investigating officer, however, ignored her statement and her concerns about her threat to life and refused to close the case. The written transcript, like there was written communication between the investigating officer and the lady. So the lady said that if I'm not going to come to this place, will you start threatening me? So it happened that excuse me. It happened that the written transcript, the communication that was taking place between the investigating officer and the lady, it revealed that the investigating officer was trying to threaten the lady that if she is not going to come down to that place, to her hometown, to her place in Karnataka and get her statement recorded, then he is going to register a false case against her husband and her personal property shall also be seized. Like your personal property will be stolen, you will face threats, you will continue to you are going to face seizure. So all those threats were given by the investigating officer to the lady and her husband. Are you understanding the facts of the case? The written transcript of the spoken wording between the lady and also the investigating officer that was submitted to the court revealed unequivocally that the IO threatened the lady and also the man with registering a false case against the person for seizure and also the girl for larceny in her house in order to compel her return to her hometown. Okay, any problem in the facts of the case? Any problem in the facts of the case? Any doubt, any ambiguity up till here? Okay, let's go ahead. As a result, on October 19, 2020, the person and the girl petitioned the Allahabad High Court for security and the dismissal of the missing person FIR. So a petition was filed by this lady Laxmibai Chandaragi and her husband before the Allahabad High Court of Judicature at Allahabad. Somebody is asking, Prasida is asking, what is larceny? It is the, theft of personal property. Theft of personal property or stealing. Mehul has rightly answered stealing. That your property will be seized and it will be stolen. All these kinds of things. Okay. So the couple filed a petition before the High Court of Judicature at Allahabad. Why Allahabad? Because the couple was living in Ghaziabad. So Ghaziabad is in the state of UP and it has jurisdiction before the Allahabad High Court. Like Allahabad High Court has the jurisdiction to cover the cases of Ghaziabad. Okay. The age was like more than 18. Okay. As a result, on October 19, 2020, the person and girl petitioned the Allahabad court for security and the dismissal of the missing person FIR. Now they wanted that this missing person FIR be dismissed because we have already told the investigating officer who came to our place while investigating the case that, and we have also written the letter to the investigating officer that we are now married and we are happily putting up at Ghaziabad and this missing person FIR has to be dismissed. So, however, even though it was requested to be scheduled for urgent hearing, the subject was not preoccupied even once a month. As a result, the couple petitioned the Supreme Court for redress. Actually, the matter was scheduled for urgent hearing because the couple was being threatened again and again by the investigating officer. The FIR was already lying pending before the concerned police station, and the investigating officer also, the investigation continued to disturb this couple. So this petition was scheduled for urgent hearing. The subject was not preoccupied even once a month, but it was not listed even once a month. As a result, the couple petitioned the Supreme Court for redress. Finally, the couple had to move to the Supreme Court for redress because continuously they were being threatened. So they were not able to go live happily and at peace and tranquility. So they were wanting the Supreme Court or the High Court to give them some relief at least. So issues: whether the investigating officer compels someone to travel to the specifically designated police station to record a statement. Okay, issues were whether the investigating officer compels someone to travel to the specifically designated police station to record a statement. Like, is it necessary? If in the guise of legal mandate, if you want a case to be closed, do you really think that it is this legal formality is so deeply required that every person has to come and get her or his statement recorded at the police headquarters for the case to be closed? Like, this was the issue before the Supreme Court because the Supreme Court wanted to find out how important this legal mandate is. Can the investigating officer do away with such formalities when a circumstance like this does exist? Like, where a person's life is in danger, and his life and her personal liberty and life can be in peril while coming to that place. Is it necessary that this formality has to be performed or completed? So whether the investigating officer compels someone to travel to the specifically designated police station to record a statement, for example, this is my opinion, this is what I'm going to say is completely my observation, my personal observation. Like, we have developed the provision for zero FIR. Do you know what is zero FIR? Earlier, people used to scurry in lurch at the time when the crime was committed against them. They used to scurry in lurch from one police station to another because they were supposed to register the FIR in the police station of the concerned jurisdiction. So this was a big issue, that you have to file this FIR and register the complaint only in the police station, which has jurisdiction to cover the place of crime. Okay, you cannot register the FIR in any nearby police station, whichever is easy to you. So we have this provision of zero FIR, which was also suggested by Justice J.S. Verma committee after the Nirbhaya rape case. This was one of the suggestions and recommendations of Justice J.S. Verma committee when criminal law reforms were suggested and recommended by the J.S. Verma committee, that the provision of zero FIR should be there. Like, you should not look after which police station has the jurisdiction to cover a particular crime scene. Okay, or crime place of crime. You should simply say that we are the police station, you are the, if there is any police station, if the FIR or the complaint can be registered before any police station, and later on it can be transferred to the concerned police station which has the territorial jurisdiction. Okay, that can be done. So why not in such cases like this, the case which we are discussing today, Laxmibai, why not in cases like this, a person can get her statement recorded in any of the police station wherever she is living, and then her statement can be transferred to the concerned police station? Can that not happen? This is my personal observation. Like, if this provision is introduced, this would this will reduce the traveling cost, the the expenses, and the discomfort a person undertakes to travel from one place to another just to get a statement recorded. And also, in cases like this where a person's life is in peril or in danger, it is very easy to get the statement recorded right at the very place a person is living, where a person is living, and later on that statement can be transferred to the concerned police station anywhere in India. If this provision is there, then why not this? This is going to make the things very easy. Okay, this is going to make the things very easy. So whether the investigating officer compels someone to travel to the specifically designated police station to record a statement, can the police officer threaten someone by pursuing false charges against them in case such persons fail to comply with the police officer's dictates? This was another issue to be discussed, to be mooted upon. Can the police officer threaten someone by pursuing false charges against them in case such persons fail to comply with the police officer's dictates? Like, every police officer or every investigating officer has a lot of powers. If you must have read CRPC, and you must have come across, and you might have realized the depth of power enjoyed by every police officer or investigating officer while investigating the case. Okay, we have certain laws for investigation, but every law has been kept aside whenever a police officer deems it fit to do anything he likes for investigating the case. At the end of the day, it is the police officer who enjoys the discretion to decide what is important for the investigation to be done. So can the police officer threaten someone? Like, police officer, does the police officer enjoy such power to threaten someone by pursuing false charges against them in case such persons fail to comply with the police officer's dictates? That is the question. Like, false charges against them in cases such persons fail to comply with the police officer's dictates. Do the parents have a say in their child's right to choose a life partner who has attained the legal age for contracting marriage? Obviously, every person who has attained the legal age for contracting marriage has a right to choose a life partner. And do the parents have a say in their child's right to choose a life partner who has attained the legal age for contracting marriage? Can society exert any influence over the matrimonial choices of any person? Like, the society is also involved in making a person do, like, pressurizing a person to make a choice. And that is not the liberty to make a choice. That is actually it's a sort of pressure. It's a sort of compulsion that the society creates, or the sort of influence, that undue influence that the society creates over the head of one person, that you have to marry this person only. You cannot look beyond this. You cannot look people beyond their religion or beyond their caste. Okay, so can society exert any influence over the matrimonial choices of any person? Okay, laws applied: Article 32 of the Indian Constitution, Article 21 of the Indian Constitution. What is Article 32 of the Indian Constitution? What is Article 32 of the Indian Constitution? I also want you to to tell me something. Why should I always continue to speak? You should always do something. You should also do something. What is Article 32 of the Indian Constitution? Constitutional remedies. How many writs do we have? Like we have habeas corpus, mandamus, certiorari, prohibition, and quo warranto. Okay, it has the writ jurisdiction and of the Supreme Court. Yes, Asta, Mehul, Goswami, Ankita, everyone is right. Everyone is right. Article 32 is also known as the soul of the Constitution. Article 32, this writ jurisdiction of the Supreme Court, or constitutional remedies, right to constitutional remedy. This is itself a fundamental right, you know. This is itself a fundamental right. Article 32, which protects the other fundamental rights, all other fundamental rights, it's itself a fundamental right. Article 32, okay, which protects all of the fundamental rights, it's itself a fundamental right. And this is known as the soul of the Indian Constitution. Why? Because if Article 32 would not have, had not Article 32 existed, you and me or any citizen would not have been able to get your right, any of your fundamental rights enforced. You and me or any other citizen in India can get his or her rights enforced by virtue of Article 32 of the Indian Constitution. So it is like a guardian. It is like the protector. Okay, so that is why it has been given this honor and token of respect to be called as the soul of the Indian Constitution. Okay, and this is exactly like that of Article 226 of the High Court jurisdiction, writ jurisdiction of the High Courts. But the writ jurisdiction of the High Courts under Article 226 is wider than the writ jurisdiction of the Supreme Court under Article 32 of the Constitution. Because the writ jurisdiction of Supreme Court under Article 32 is exclusively exists only and only for I'm sorry, excuse me, only and only for getting your fundamental rights enforced. Okay, only your fundamental rights. No other right would be redressed here under Article 32 before the Supreme Court. But High Courts have the power to redress any of your right, including the fundamental rights as well as other legal rights also before under Article 226. It's writ jurisdiction under Article 226. of the Indian Constitution. So the laws applied were Article 32 of the Indian Constitution and Article 21 of the Indian Constitution. 21 we have discussed like many times. The court directed that the FIR filed by the parents be quashed in the hope that the parents of petitioner number 1 can have the better sensibility to simply accept the wedding and re-establish social engagement not only with petitioner number 1, the woman, but also with petitioner number 2, the man. The court simply directed, like this judgment, like I have come up with only exclusively dealing with this issue, whether the parents have a right to do or participate in the marriage process of their children or not. That is the issue here right now. We are reading. Okay. Heart and soul of the Constitution. Yes, Mehul, right. So, yes, Ankita, you are right. Okay, so the court directed the FIR filed by the parents be quashed. Do you know the FIR can be quashed by the high courts also? Earlier, they must have filed the petition before the Allahabad High Court under which provision? Under which provision the petition for quashing of FIR is filed? Under which provision the quashing of FIR is filed? Under which petition, under which provision the quashing of FIR is filed? Section 482, right. Chitra Lekha is right. You have rightly answered. Yes, Muhammad Riaz. 482 CRPC. 482 CRPC. Yes, 482 CRPC. So what is 482 CRPC? Simply the power to quash the FIRs, or what is written there in 482 CRPC? What is written there in 482 CRPC? Yes, Mehul Gangwar, 482 CRPC, right? I'm asking what is written in 482 CRPC? Do you know what is written in 482 CRPC? Inherent powers of the High Court. Very good, Muhammad Riaz. Inherent powers of the High Court. Like, why these inherent powers have been given? The inherent powers have been given, like, it's not just the quashing of FIR. Albeit you can say that the quashing of FIR is the most frequent thing which is sought for under section 482 CRPC, but that this provision is not exclusively for quashing of FIR. These are the general inherent powers of the High Court. Yes, everyone is right. Somesh, Somasundaram, Zinia Potter, everyone. Inherent powers of the High Court, discretionary power to prevent abuse of process. Like, this is a general provision, containing general inherent powers of the High Court. This provision does not exclusively deals with quashing of FIR. Quashing of FIR is one of those things which the High Court can do as part of its inherent powers. So it's not just the quashing of FIR that is sought under section 482 CRPC. It can be anything of that sort. Okay, it can be anything of that sort. So quashing of FIR is usually sought as a form of High Court's inherent power to do this. Simple. Okay. So the court directed the FIR. Here the Supreme Court directed the FIR filed by the parents be quashed in the hope that the parents of petitioner number 1 can have the better sensibility to simply accept the wedding and re-establish social engagement not only with petitioner number 1, okay, very nice. Very nice. Baat Jazbaat Tum is also making right observations. High Court can make such orders as necessary to give effect to any order under the code. Very good. Very good. Yes, that's right. Or to prevent abuse and secure justice. Yes, Zinia Potter is also commenting to prevent abuse of the process of any court or otherwise to secure the ends of justice. That is also very true. That is also very right. Okay. So the court directed that the FIR has to be quashed. The court also said that the parents should, this FIR should not only be quashed, but the parents of the petitioner number 1 should re-establish their social engagement with petitioner number 1, the woman, and also with petitioner number 2, the man. They should accept their wedding. They should re-establish their social bond with their daughter and with their son-in-law. It's not just we are sitting here to get this FIR quashed. We want these kinds of things to be completely eradicated from the society. We are sitting here to cure the mental illness that people suffer from. It's not just that we are simply here to quash these kinds of FIRs. We want these parents to accept their daughter as she is and along with her husband. So you have to re-establish. You have to first accept the wedding, and then you have to re-establish social engagement with the petitioner number 1, the woman, and also with the petitioner number 2, the son-in-law. Okay. Ankita, what do you mean by suo motu proceedings? Suo motu proceedings are completely different. The Supreme Court can undertake can take suo motu cognizance of anything it comes across. Okay. The question here was not the issue was not the issue was not taken cognizance of by the Supreme Court. It was not a suo motu cognizance. It was actually a petition which was filed before the Supreme Court on which the cognizance was taken. Okay, suo motu cognizance was not taken here. Suo motu is khud se, automatically, like when the court takes cognizance of something without receiving any petition on an issue which the Supreme Court comes across and which is an issue of national importance, which the Supreme Court or the High Court thinks it has to be decided by it, and it bears a question of law. Only those things are taken suo motu cognizance. In only those things the suo motu cognizance is taken by the court, higher judiciary. Chitralekha is rightly commenting. Okay, is rightly commenting. Yes, Chitralekha, you are absolutely right. They are not suo motu proceedings. Section 482 petition needs to be filed by the party. Yes, no, you are not wrong, Chitralekha. You are not wrong. You are absolutely right. Okay, so suo motu, this is not these are not the suo motu proceedings. These are not the suo motu proceedings. Now, the judges hope that such an exercise in opposing one's child and their relationship on the basis of caste and community would not be fascinating. Okay, the judges hope that such an exercise, like if the parents in today's society, like society of the 21st century, where people are like gaining the knowledge of the starry universe, And the rocket science is no more a rocket science in today's world. It is very astonishing that people are still living with this mental setup that their child cannot marry a person of his or her own choice. This is what the Supreme Court says, that every time these kinds of things take us aback by shock, that why parents do exercise an opposition against one's own child whenever they want to marry a person of their choice who happens to belong to another caste or community. This opposition is not fascinating. This is not at all fascinating. The judges hoped that such an exercise in opposing one's child and their relationship on the basis of caste and community would not be fascinating. Okay. Okay, then second, it directed the IO's subject matter. It also urged police agencies to develop a training program and write down guidelines for traumatizing such socially sensitive cases within the next 8 weeks. Now, it urged the police agencies, the Supreme Court said, like on the second front, the Supreme Court dealt with the IO's subject matter or the issues regarding the investigating officer, that it urged the police agencies to develop a training program and write down guidelines for traumatizing such socially sensitive cases within the next 8 weeks. Like, it directed the police agencies that you have to develop a training program. You cannot simply leave your investigating officers like this to traumatize people in such socially sensitive cases. You cannot simply stick to your legal procedure if it does not have any flexibility to come down to that place, even while putting her life at risk. This should not be like so rigid. You have to develop a training program how to deal with the victims of crimes. Okay. So you have to develop the investigating officers needs to be trained. So develop a training program and write down guidelines for traumatizing such socially sensitive cases. If your investigating officers do not have this ability and capability to deal with such socially sensitive cases in a proper and appropriate manner, then train them. You have to train them. So the police agencies were directed to develop a training program and write down guidelines for traumatizing such socially sensitive cases within next 8 weeks. Okay, analysis. Now, what is the analysis? India is undeniably developing towards a better tomorrow, yet events in which a family threatens their own children, severs relations with them, and forces marriage on them kill the human nature of society faster than a virus. Like, we can talk in terms of viruses now, because it's like we have become accustomed to living with coronavirus, and the way it spreads, the pace at which it spreads might be slow than the kind of viruses which is there in our mental setups. Like, this harms and destroys and dismantles the society at a faster pace than a virus. So India is undeniably developing towards a better tomorrow. We are like the second largest growing economy in the world. We are like Asia's rising superpower. Okay. Somesh is commenting, people do not accept intercaste marriages easily. I wonder how will they react on some same-sex marriages. Like, see, some religious points are also involved in same-sex marriages. So let us not discuss same-sex marriages here. because this is a very sensitive issue, different religions have treated it differently. So we should also take care while discussing these things that nobody's religious sentiments be hurt, should be hurt in this case. Okay. See, whatever happens, we should not come down to killing our children. At least if somebody is not accepting the marriage, we should not at least come down or stoop to such new lows to start killing our children. This killing of the children is not allowed. This is truly uncalled for and highly unbecoming. Okay, so India is undeniably developing towards a better tomorrow. Yet events in which a family threatens their own children, severs relations with them, and forces marriages on them kill the human nature of society faster than a virus. The Supreme Court's sensitivity in handling this case is unquestionably commendable. Furthermore, it not only held that the freedom to choose one's partner is a right to life, but it also advised police authorities to take a different approach when determining instances of this sort. The police role in such circumstances is critical. If not done with extreme caution, it not only violates a person's right, but can also result in disastrous and terrible outcomes. So this is all about today's case. If you have any question or query, you are most welcome to ask. Yes, it's a constitution case, Ankita. Anything that involves fundamental right, interpretation of your fundamental right becomes a constitutional case. Okay, then I guess things are clear to you. So I'm ending this stream. Thank you, Chitralekha, Goswami, everyone, and for telling me that you have no doubts relating to this case. Okay, so all the very best and see you tomorrow. Bye bye.